First of all, I want to say thank you for WIPO, for Israel, for possibility to take participation in such interesting conference. Second, I want to say sorry for my English. WIPO promised me maybe you will have translation from Russian into English. I have no, so it is better, as in Russian I can speak about this protection of decay from morning till night without stop. So I have no time. That must be short. Yes. Professor Pamela was so kind, and she wrote me and sent me her presentation. And when I read it, I made some comments, short comments, and some points I write down. I will listen to you very attentively at this point. I agree with you. I fully agree with you. You highlight all the main points of this subject. So, and I add something, maybe. So I want to add something very shortly, as my speech is not first and second and so on. So many things was we hear there. As I have 5 minutes, so my speech begins. Sorry, my English. What is the relationship between IP protection and preservation as safeguarding? Within the context of cultural heritage, including decay, the notion of preservation and safeguarding refer generally to the identification, documentation, transmission, revitalization, and promotion of cultural heritage in order to ensure its maintenance or viability. And we must, speaking about protection, we must touch these problems. What is the role of public domain, legal options, national, regional, and international trends and experience, and setting national policy objects? They may be different. Form of protection. Then we may investigate using of existing intellectual property laws. The policy debate about TK and IP system has underlined the limitation of the existing IP laws in meeting all the needs and expectations of TK holders. Even so, existing IP laws have been successfully used to protect against some forms of misuse and misappropriation of TK, including through the law of patents, trademarks, geographical indications, industrial designs, and trade secrets. However, certain adaptation or modification of IP law may be needed to make it work better. We can list, I want to list some laws which may be used for protection of TK. It's unfair competition, patents. When practitioners innovate within the traditional framework, they have been able to use a patent system to protect their innovation. For example, in 2001, China granted 3,300 patents for innovation within the field of traditional Chinese medicine. Distinctive sign, trademarks, collective marks, certification marks, geographical indication, traditional sign, symbols, and terms associated with TK have been protected as marks and have been safeguarded against third parties' claims of trademark rights. We have example from Mexico, from other countries. unfortunately, I have no example from Russia. I don't know why. The law of confidentiality may be used and trade secret. This has been used for protected non-disclosed TK, we mentioned it, including secret and sacred TK. Customary laws of communities often require that certain knowledge be disclosed only to certain recipients. Next, maybe adaptation of existing IP through sui generis measures. A number of countries have adapted existing intellectual property system to the need of TK holders through the sui generis measures for TK protection. New example, New Zealand. Trademark law has been amended to exclude trademarks that cause offense, and this applies especially to indigenous Maori symbols. Sui generis, use of sui generis exclusive rights. In some communities and countries, the judgment has been made that even adaptation of existing IP rights system are not sufficient to cater to the holistic, unique character of TK subject matter. This has led to the decision to protect TK through sui generis rights. Other legal concept for the protection TK, prior informed consent. According to the principle for prior informed consent, TK holders should be fully consulted before their knowledge is accessed or used by a third party. Then equitable benefit sharing, the idea of equitable balancing of interest in common, is common to many legal systems. Unfair competition and respect to customary laws and practices. Customary laws, protocols, and practices often define how traditional communities develop, hold, and transmit TK. I want to return to patents. For example, has no country national. If we made everything according to the laws, every laws which I listed, let us consider the following situation. For example, patent for invention which is using TK was granted. The applicant signed with representative of the traditional community, right holders, for the TK, the prior informed consent and agreement on equitable distribution of benefit. The terms of prior informed consent and agreement on equal distribution benefit was fulfilled. After 20 years, this patent where the TK was used is moved in the category public domain and may be used without any limitation. At the same time, according to the draft article on TK prepared by all countries in WIPO, TK should be protected without any limits of terms. Considering above states, we have a question. Which of these contradictory norms should be applied, and which will be the terms for protection of traditional knowledge? Terms for protection of traditional knowledge will be the same as the terms of protection of patent, which use it. Terms of protection of TK, despite the existing patent regulation and law, will be unlimited or something else. Nobody knows answer this question. But I want to say the next one. that the law are not enough. One of the main lessons learned from our work so far is that having a law for protected of TK is not enough. Laws have to be known about, and the communities and persons that are intended to benefit from them must relatively easily able to gain, manage and exercise rights under the law. In addition, government service need to be able to give practical assistance to communities, and legal advisors need appropriate information to advise their clients. For the effectiveness protection of TK, therefore, broad awareness raising and training are needed, as are legal aid and appropriate institutions that can help communities manage and enforce their rights. C'est tout.